So thank you so much, Joaquin, for having us. My name is Rita Mosa, and thank you all of you for joining us on the online space. So we'd like to know, who is Wakili Manwa Hosea?
Thank you so much, Rita, for the interview. Manwa Hosea is an advocate of the High Court of Kenya of 5 years post-admission. I'm also a father of 3 and a managing partner at Otwal and Manwa Associate Advocates. Yes.
So can you take us through your educational background? Yeah.
As you've noticed, I'm 5 years in practice, so my journey is not as old as you'd expect. I joined primary school in a village school in Hakithi, called Bonuria Boarding. And then after my primary school, I joined high school, Nyambaria Boys. I think the national, they actually number 1 in the last KCSE example.
Yes.
After Nyambaria Boys, I later on joined Moi University School of Law, where I pursued Bachelor's of Law, LLB, and graduated in 2015. And then after 2015, I managed to join Kenya School of Law in the year 2016. And then, of course, after Kenya School of Law, I was admitted as an advocate of the High Court of Kenya in the month of March 28, 2018.
All right.
So I've been in practice for basically 5 years. I'm now doing my 6th year of practice as an advocate of the High Court of Kenya.
Okay. So Wakili, what inspired you to do law?
There are so many things that inspired me to do law. You know, these inspirations come in between. You know, when you're in high school, I was so passionate with law, because I felt people I admired who are in practice. Then I think Senior Counsel Orengo, now Senator, now Governor, was one of my inspirations because of his work within the legal space and his fight for democracy at the time. I had other people who inspired me. Senior Counsel Amin Nasli Abdullahi, at the time he was in the leadership on the Law Society, and so many others who have come after us and who have made a mark within the legal practice. And so these people, together with my personal understanding of the law, gave me the opportunity to perhaps pursue a career in law, which I think so far I don't regret.
Okay.
Yes.
So what has your experience been like practicing law in our country?
Yeah, within the 5 years of practice, I think I have learned a lot. It's been a learning experience. Because, as you understand, ours is a common law country in terms of law. And I think I started my law firm immediately after admission. Immediately after being admitted in 2018, I started practicing. I started in my house.
Yeah. Okay.
And of course, progressively, I've been practicing for 5 years. And of course, it's been a learning experience, challenging, but again, fulfilling. Yeah.
So what are some of the challenges you can mention?
Of course, there are so many challenges that young lawyers experience. And I think every year when young lawyers are admitted into the bar, you expect them to be subjected to a rigorous process of training. And I usually say that the Kenya School of Law generally does not prepare us for practice. It sends us into this animal called the legal profession. And of course, whereas we have the training, the theoretical training of lawyers at the Kenya School of Law, and the exams that are set by Council for Legal Education, largely there are great challenges that the young advocates of 0 to 3, 4, 5 years experience. That is the jobs. There are no jobs within the legal profession as expected, and of course that is something we'll need to speak about later on. And so there is that challenge in the initial years of practice when you are not able to secure an employment.
Yeah.
And even if you secure an employment, then that employment does not generally help you sustain your needs as a young lawyer. And I think that's a major challenge within the practice. The second challenge is acceptability in our courts. If you're young, obviously the court sometimes treats you with some level of contempt. And I think that is something that we also need to address. That even as we are learning within our court system, it's important that the judiciary appreciates these young people. Remember, they're the ones who admit us. So they have to assist the young counsel in ensuring that actually they grasp the practice environment, are able to understand what is more important for them within the practice, guide them within the court systems to know what is more important, how to address court and law, and so on and so forth. So for me, I think that is the biggest hindrance in practice. And obviously, with the stakeholders, the law side of Kenya, the Council for Legal Education, Kenya School of Law, the judiciary at large, needs to put hands together to help young lawyers transition from pupillage to practice, so that it's not a curious task for a young lawyer to struggle within this case without knowing where do I belong. And of course, again, there is also the challenge of not knowing yourself. The legal profession is wide. We have those lawyers who go into private practice directly after admission, like myself. We have those who go into employment but don't know what they want in employment. Do they get into litigation? Do they specialize in other areas? Do they pursue further academia so that they can actually join the judiciary or or teach in our institutions? So there is that challenge of picking a practice environment that you can grow with. And so there are huge challenges, including welfare issues, not to be able to have medical covers. And I think that is a big challenge to most young lawyers. Having served under TIBA, I have experienced the struggles that young lawyers go through. And I think it's something that we need to address as a community to be able to ensure that our younger colleagues do not have misses within their years of practice. Because I think your first 5 years will shape the entire practice of any young lawyer. If you make mistakes within this period, then obviously it will affect your gradual growth into the profession.
Okay.
Yes.
So, Akinle, I'm sure you've heard of the brand vendor issue. What is your reaction on that?
The brand vendor issue is unfortunate. Number one, I want to speak into the misinformation that came with it. That the gentleman had handled 26 cases. I have challenged a few people to, in the media, to actually give us the citation of these cases. But of course, they don't have that information. And I think we have suffered as a profession because of misinformation. It's good that he was identified in good time. I don't think he has been masquerading for more than 9 months. And the identity theft, of course, of an actual advocate is an issue in itself. But I think it's important to face this challenge as a profession, because masquerading happens in every other profession in this country. So look at medical practitioners. You've seen the fifth Dr. Mugo, who was convicted and sentenced to imprisonment for purporting to be a doctor. And so many other cases, not only in the medical field, but even in the engineering field and those other professional bodies. And like in engineering, someone who's not an engineer will tell you, I'm an engineer in this sector, and obviously they go scot-free on that. So there is need to address the root problem. I think for us to avoid masqueraders, and my position is quite radical, but I have seen it work elsewhere. As it stands today, an advocate has the ability to change their photos on the portal. Once you log into the Law Society website, you are able to change your profile. And I think we need to ensure that this portal is protected. And my proposal is that we start afresh. Collect this data afresh from advocates, because sometimes you will be an advocate, but you don't know how many who's using your name where. And in the work of e-filing, processes, because the judiciary nowadays does not accept physical documents, and all the filing must be done online. And in the work of online courts, it's important that now we overhaul the entire LSK portal and replace it with, or rather we start afresh by inviting advocates. And I think the Law Society can afford this process, because all they need to do is to ask advocates to come back and re-register. And they should have the capacity to take photos. When you take a passport, for instance, it's the government that actually takes the photo that appears in your passport, because they want to see the actual person. Why is it so difficult for the Law Society to set up this structure in a way that members can re-register? All I need to do is to visit the Law Society, or we devolve it into branches where an advocate is supposed to use the biometric to register their biometrics. And secondly, the Law Society takes a photo which will appear in the portal, and any other details that they want. That way you secure the system from attack from the public. At the same time, the content, you have control of the content that is on the portal, to avoid the identity theft that has happened. And you see, Brian Mwenda will not be the first and last cases. There are so many masqueraders within our systems, and we need to be very deliberate as a society in ensuring that we protect this practice space. And remember, these masqueraders are the ones who are actually undercutting. They're the ones who are filing, documents in court that are not competent. So they're demeaning and lowering the credibility of the legal profession at large, and we have to fight that, because we have an entire legal profession to protect.
Okay.
So for me, it's a wake up call, and I think the Law Society has a duty. Even our courts, there's a duty for the courts to ascertain who appears before them. They have a duty to check, and I think it's important that they also check with the Law Society. There's a toll number. The judiciary has direct access to the Law Society. Remember, they are also members of the Law Society. So it's very easy for a judicial officer to ascertain the identity of the individual appearing before them, and at the same time to ensure that these individuals are advocates, are actual advocates who have practicing certificates for that particular year.
All right.
Yeah.
So, Kini, what is the current state of the Kenyan judiciary, and what is your opinion on it? Do you think it's independent?
The Kenyan judiciary has its shortcomings, I might say, because having practiced for this period from the lowest to the highest level of our court systems, I'm talking of the small claims court to Supreme Court. As a practitioner, I feel like there's a lot that needs to be done. If you look at the judiciary as presently is, you will notice that there's challenges with regard to first the judicial officers. There's an aspect of huge corruption going on within our judiciary. And I think it's a huge concern for any advocate who has practiced law in our superior courts or in the law courts. They'll tell you that they have witnessed and experienced this. And I think that is the biggest challenge that we have in the judiciary right now. And I feel it is time to have another review of the judicial officers and ascertain who's not doing his or her work properly. But of course, beyond corruption, we have the problems of backlog, so many cases staying and not being determined within the timelines. We have the issue of dates. If you go to the registry at Milimani today, especially the magistrate courts, you will experience a lot of problems on commercial matters and the challenge of not having matters expedited the way the law envisions. And so the aspect of the court giving you dates, for instance, right now we're getting dates from March, some courts February, some courts April next year, over matters that should have otherwise been determined earlier. Of course, there is the aspect of not having sufficient sufficient judicial officers, but it's a going concern, and I think it's important that the judiciary recruits enough judges and magistrates to meet the backlog. There's been progressive recruitments over time, but there's no change in terms of expedition of the cases. So the judiciary has to find out what is the problem. Is it the judicial officers who are insufficient, or the judicial officers that we have are not actually pushing towards ensuring that the judiciary works seamlessly? And of course, there is the aspect of corruption within the registries, where the judicial staff, the clerks and the people who work at the registry, connive with the other parties to get higher dates. I will address also the concern with regard to the Court of Appeal.
Okay.
And if you monitor the cases and the movement within the Court of Appeal, you realize that some matters that are certified as urgent, because the tradition is if your application under 5.2b has been certified as urgent, it ought to be presented before a three-judge bench for determination. Does that happen in actual practice? You tell me. A few matters will be certified urgent, but you will take close to 2-3 months to be heard substantively. Some matters will be certified urgent, they'll take 2 weeks to be heard. What is the criteria? So that is a problem that we need to address, and I think it's important that we push it forward.
Okay.
Yeah.
So are there any other ways that you can suggest for tackling the corruption that within the court registry?
The corruption within the court registries can only be addressed if the Chief Justice takes her duty seriously. I think it's important that they even visit these registries to ascertain whether these judicial officers and the judicial staff meet their obligations. There is a simple way to do this. It's by ascertaining when was the matter filed. How is it that some matters are expedited and some are not expedited? What happens with the dates? And you see, one of the concerns that advocates have been addressing is you find that judicial officers go on vacation or go on leave, yet they had matters scheduled to be heard before them. So it's important that we ascertain and get to know why there is that disparity in terms of judges not following up the calendars set and perhaps proceeding with the matter that was set for that particular time. Yeah.
Another matters, I'm sure you've heard of the land issues that we've had currently, the Mavoko demolition,
yes,
and the Kirima land fiasco.
Yes.
What do you think can be done to address this issue?
The demolitions in Mavoko and Athi River and Kirima issue is, I don't know. There is a general feeling that most land purchasers do not adhere to the process of transfer of property. And I think if the general public were advised properly that actually you need to find a competent lawyer to be able to pass through your conveyance from the beginning to the end, because a proper lawyer could have conducted what we refer to as due diligence. From the start, from the pre-purchase search up to the time the purchase has been done to post-purchase search. And one of the due diligences an article is supposed to conduct is to ascertain whether this is public or private land. And I think based on that background, I think it's important that the general public are sensitized as to who should, as to the importance of having a competent advocate. And I think, of course, our courts have pronounced themselves that this was public land, or the Kirima land was private land. So it's upon the court and, of course, the owners of the properties to find an amicable solution. But again, there is no going back as to if you acquire a good title on land that belongs to the public, it's obvious that it will be taken at some point by the government, and even ascertains that actually the land was sold to you, yet it was public land. Yeah.
So handling the elephant in the room.
Yes.
You're running for NSK general member.
Yes.
What inspires you to run for this position?
Now, I have served I've served members in different capacities. I will start with the young bars issue. In 2020, we started what we refer to as TBA, the Young Bars Issue. The Young Bars Issue has been instrumental in championing for welfare issues. And I think obviously the purpose of TBA as a body was to bring together advocates and essentially to address matters welfare. And I think to that extent, we succeeded much. I left office last year as the founding chair. And of course, the TBA team has a new leadership. We are hoping that we can be able to unite the young bar. Remember, the senior bar is recognized under statute. I don't know if you know that. The senior bar is recognized under statute, but the young bar, we only have a committee of young lawyers under the committees of the law society. There is need to ensure that we unite the young bar, and I think I'm graduating soon to the mid bar, but I believe that the unity of the young bar can actually propel you and address the small concerns like welfare issues. If you look at the welfare of young lawyers as it stands right now, if you do a statistics, you'll find that most of the young lawyers do not have a medical cover. Why? It's because they do not have capacity. Some of them are not in employment. How do we address it? How do we look for solutions to, cater for the young lawyers? It's by bringing them together. And I think during our time, we negotiated a last respect cover. This last respect cover was, in 2020, 2021, we lost so many people and parents due to COVID. And I think the only solution we had was to pull resources together, contribute, and exercise the numbers that we have to raise resources to enable our members to bury their loved ones. Of course, we were in the process of negotiating the medical cover, but I think it's something that the new team is taking up. And over time, obviously, I'm sure that they'll be able to perhaps have a medical cover where young lawyers are all included in actually having a proper medical cover. I know most of us have families, most of us have parents to take care of, and I think these negotiated covers for young lawyers can take as far. I think that was the first reason why I decided to run. The second reason is that, of course, I've been representing. Before we were admitted, the Council for Legal Education introduced what we refer to as pre-bar exams. And I think yourselves and even the rest of the membership have benefited from the suit that we filed under the Law Student Society of Kenya, a society I founded, which of course led to the launch of the Law Student Society again recently. Under TBA, we managed to fight the introduction of pre-bar by Council for Legal Education, which subsequently was thrown out by Honorable Justice Odunga on the basis that we had legitimate expectation as students to join Kenya School. Above that, I've represented the Law Society in public interest litigation matters. Quite a number of them, the Kenya Meat Commission matter, the transfer of Kenya Meat Commission to the Ministry of Defense. I've represented members in the transfer of judicial commissions and independent offices to be under ministries. It's a petition that we filed before the High Court on behalf of the Law Society, and the court set aside the same, amongst other matters that the Law Society has given me to pursue on their behalf. Those are some of the reasons why I'm pursuing. I've decided to tender my candidature for general member representative.
Okay.
Yeah.
And briefly tell us, can you summarize for us your manifesto?
I think there is much that a general member is supposed to do, because the Law Society, the way it's structured, everything is on collegiality. You have to agree as a team, and of course the president is the spokesperson. The reason why I ran and what will constitute my manifesto is to ensure that there is access to justice, especially in our courts. The Law Society has a duty to ensure that the judiciary checks it. It has a duty to check the judiciary to ascertain who are the judges who are complacent and who are corrupt, to ensure that our registries work. Of course, we have the bar bench committees, which are being left to the branches. I think the branches are overwhelmed and they are not properly resourced to actually handle some of those issues. And I think the main office, the council, has a duty to follow up and ensure that advocates have a free environment to practice without any problems, without the issues of corruption, the issues of dates, the issues of judicial officers taking or going away without notice, and the issue of respect of young lawyers when they appear in those offices. Above that, obviously, we also need to address the aspect of accountability. I stand for accountability of the members' funds. We contribute a lot to the law society, but members have concerns as to how their money is utilized. And I think I stand with accountability, a society that is able to account for its resources. My simple proposal is also to push for a 3-month SGM. Every 3 months, the Law Society ought to have an SGM for members to first audit the 3 months, because the 2 years in office is too short. And we have 2 SGMs for every regime. It's not sufficient for members to actually audit its officials. And so a 3-month SGM will enable members to review what the Law Society has done within that short time. At the same time, ascertain or approve any other expenditures that will be intended in the next 3 months. That way, members will not have concerns about their resources, utilization of their funds, and at the same time, they will be participating in the activities of their society as it ought to be. So those, among other issues, are the reasons why I chose to declare that I intend to run for general member representative in the coming election.
Okay. So how can you rate the performance of the now LSK council?
I don't know. The Law Society itself, as constituted, has had its challenges. And it will be unfair to rate them in any way, because I think so far they are still in office up to next year. But I can speak as to what they have not addressed. And I think the question of the access to courts, I think if you ask any advocates, they'll tell you the question of dates is a big concern within the judiciary. The question of subsidizing PCs is a huge concern within the judiciary, within the legal profession, especially for young lawyers. The issue of ensuring that there is consistent accountability of members' funds. And I think those are huge concerns that come from the membership. It's very important because the Law Society belongs to all of us. And so there is that concern that I've had, and of course I've experienced as an advocate, that they have not addressed with regard to accountability and access to the projects and activities of the Law Society, and seeking for members' approval in terms of every step they take towards utilization of the members' money. So those are the concerns that I have. But of course, they have tried in terms of public interest litigation. I've seen the president institute proceedings in court against the government on decisions that are against the constitution. I've also seen them, of course, address the PC issue, even though it was the CPD issue, even though it was presented by one of the members to seek for subsidizing of the online CPDs from the initial 2,000 that we were paying to 1,500. At the same time, giving 2 CPDs for an event worth 1,500. So I think those are the few things that I've seen that they have done. I have not seen anything from the general member representatives in terms of pushing the members' welfare issues and concerns, and I think I'll be interested to debate my opponents going forward, including the incumbents, as to what they have done for the society, so that members can be able to pick the best candidate going forward.
All right. So, Akili, since you're running for the LSK general member, what will you do to ensure that the young advocates feel involved in the affairs of the
For me, it's very simple. The Law Society is one cake. And I think it's important that we cut the cake according to the membership. There are huge appointments that come to the society every time. It's important that we also allow both the senior bar, the mid bar, and the young lawyers to actually take those positions. We have opportunities of individuals who are supposed to represent the law society in tribunals.
Mm-hmm.
And I think within the young lawyers of 0 to 5 years, I have met advocates who are doctors, who have PhDs, who are 0 to 5 years. I've met doctors who have advocates who have masters. So they are eligible to these positions. Why is it that, of course, they do not get these opportunities? And I'm not saying those who get these opportunities do not deserve them. All I'm saying is that we split the cake in equal measure within the three categories to bring a balance. And I think that is empowering young lawyers. That is one way that they can empower young lawyers. The second way that we can involve young lawyers within the law society is to expand the young lawyers committee from 15 individuals or 30 individuals, as it is the case right now, to at least 2,000, 3,000, because we are huge. If you look at P105 14, 535, stroke 18. Now we have P105 21,000. Is it 21 or 22,000? Heading to 23,000. So what I'm trying to say is that 0 to 5 years, there is a huge number of young lawyers who have been admitted. How do you represent them properly? Empower these young lawyers associations. Like TIBA was registered with the help of the Law Society. And the Law Society gave a letter of no objection to register TIBA. These activities that we have as a society, and of course we have CPDs and all that, we can do something extra to accommodate the young ones into the activities. I usually see whenever it comes to young lawyers, CPDs, they say it's free and they don't award a CPD, which is unfair. If you have to carry a CPD for young lawyers, then give a CPD and subsidize, so that these people can also be able to meet the requirement of 5 CPD points per year. So I think that is important, and it's crucial that we involve them in those activities. We can have activities earmarked towards targeting young lawyers, so that we can accommodate the huge number as we go forward. Of course, we have a huge number of the mid bar and senior bar. But again, the young lawyers are the most vulnerable, and they're the most, because if we ignore them, then obviously we will have problems with regard to undercutting, because an advocate must survive. And then in addressing undercutting, we must also address the young lawyers, and also formulate ways to create employment. I think the president of the Law Society sits in the Justice and Legal Affairs Committee. I think it's important that we find opportunities for young lawyers like research within the judiciary. We need to create opportunities by empowering branches and creating opportunities within those branches to ensure that at least young lawyers are consumed. Of course, even in the public sector, there is need to sensitize and find opportunities for advocates within these spaces. So there is a lot that needs to be done. Of course, also ensuring that the young lawyers have the willingness to participate in these activities that are presented by the Law Society, and also for them to belong, to feel like they belong to the Law Society. Okay. Yeah.
And what do you think should be done so that advocates are remunerated?
Yes.
Remunerated.
Yeah.
Promptly and better while they take up this pro bono matter?
My position on the pro bono issue is different from the one that has been presented. I have seen different branches issue ultimatums that they will not handle those matters going forward. I think the Law Society has a duty to perhaps issue a statement asking all members to stop as a radical measure, because the judiciary has a duty to pay the pro bono lawyers. Remember, the requirement for representation is constitutional. provided for under the Constitution. And the judiciary has an obligation, of course, to ensure that they find legal counsel for these individuals. I find it very difficult for an advocate to take home 30,000 as a payment of representing a capital offender, a suspected capital offender. Remember, it's in capital offenses like murder, robbery, violence that the state requires that you get an advocate. At what point do they become pro bono matters? That is where the problem is. If we have other advocates representing other state organs and they bill their costs through the ARO, the Advocates Remuneration Order, it's only prudent that we have these advocates whose services are required on capital offenses to also bill under the ARO. And we can change the law to allow that, so that this problem is solved once and for all. There is no dispute as to whether the state the state ought to do it, because the Constitution has said you have to provide these individuals with representation in form of advocates. It's for them to look for resources, and that's why I'm saying even if they increase the amount to 50,000 under this economy, even if they push the amount to 100,000, remember these matters take 2-3 years. Are you offering proper justice to this individual by paying an advocate 30,000 to represent an accused person for a matter that takes 2-3 years? And is it even in pro bono in nature? Because you see, most of the people who take these matters are young advocates. But if you look at the way they are treated in terms of remuneration, it's different. And why do we selectively pay these advocates that amount of money, but the advocates who bill to scale in other state, or rather who represent the state in other matters, actually bill to scale? So there's need to change that law generally, and I think that is what that is a bread and butter issue. The Law Society, if it's serious, it has to stop the entire process until we renegotiate with the judiciary on the proper remuneration based on the current economic times, so that now those advocates taking up those matters, they ought to be paid upfront, or rather 45% of that amount should be paid upfront. The amount should be actually increased to at least a minimum of 100,000 per case. Because the problem is you're given a matter which has 3 accused persons, but because it has 1 case number, you're told you'll get 30,000. So per an individual, at least an advocate should get 100,000, at least for now, so that it can be able to meet the advocate's needs in terms of attendance of court and all that. And you see, these risks go to young lawyers, and that's why it's important that for the judiciary to negotiate with the law side, then we have to stop taking up those matters, because it's not our duty. It's not the duty of the law society to actually get representation. It's the duty of the judiciary. And if they are not meeting the requirements, even of the 30,000 alone, then there's a big problem. And how do you challenge it? And I think in other organizations like teachers, you've seen Sosione as he was. He will tell his members to down the tools, and they will listen. The president of the law society has a duty to ask members who do the pro bono matters to down their tools until we have a meeting of the mind with the judiciary as to what is suitable to pay an advocate for pro bono matters, especially on the matters that the judiciary gives out as per the law.
Okay, so we all know that the legal space is now ever-changing.
Yes.
And what do you think, what advice can you give to young lawyers so that can remain competitive in this space?
Yeah, I think I was admitted 8 years after the new constitution had been promulgated. And I think the law has since changed from 2010 to date. We have actually repealed most of the acts that were enacted before the 2010 constitution. And of course, the practice of law keeps on changing every time. 5 years ago, oil and gas was a lucrative area in practice, and lawyers, of course, pursued masters in those areas and pursued practice in those areas. We have IP, which was equally a lucrative area 5 years ago and an emerging area. Now, currently, we have artificial intelligence as a current a niche in terms of where the practice is going. And of course, we don't ignore any sector in terms of how many jobs it will create and how it will impact our practice. So I think every generation has its emerging areas. Like now, the current generation has the artificial intelligence as an emerging area of practice and the challenges that come with it. It's important that young lawyers are alive to these realities and grab these opportunities as they come. And of course, the traditional practice areas are still there. That is, conveyancing, litigation, and depending on which area. And I think as a start in practice, there is no need to specialize because the opportunities are immense once you understand the process. And then now, after a few years of practice, when you discover your strength, then you can now start to specialize in a particular area, in a particular field of practice, whether it's employment and labor matters, whether it's in the land and environment, whether it's family. I know of young advocates who are specialists in family matters. I know some who are specialists in land matters. And I think over time, you're able to now select which area you can actually base your practice on and push with it. So the opportunities are immense. We need to open up to these areas. And of course, we don't need to have one area. We can start practicing all the areas and, gain experience with them. And then later on, we can specialize. Yeah. And I think those opportunities are available for all young lawyers to grab.
All right.
Yes.
So away from that, how would you rate the Chief Justice, Martha Koome, since assuming office?
The Chief Justice so far, and I think I've addressed the concerns I have within our court systems. There is a big challenge in terms of access to justice now more than ever because there are growing concerns and the question of corruption. And I think the judiciary is headed by the Chief Justice and the President of the Supreme Court, Martha Koome. So far, in terms of addressing practice concerns, I think in terms of the small claims courts, she has really done well by opening up courts across the country. But again, whereas that is good, if we have corrupt adjudicators, judges, and magistrates, then obviously we are not actually ensuring that justice is met, or rather, those opportunities created by opening up courts does not in any way help the practice environment with lawyers and even the general public. And I think that is one of the concerns. I've spoken about the concerns within our registries. I do not know whether the Chief Justice gets periodic reports as to how the courts and whether the judges sign performance contracts to ascertain that they have met certain goals within certain periods. And I think it's important, and I don't blame the Chief Justice alone, but I think we have the Judicial Service Commission that disciplines judges and magistrates. They are also sleeping on their job. You have seen what is happening, and I think you have seen a judge being recorded and taking a bribe from another person to make a determination in a case. And that is a serious indictment on the judiciary as it stands. Because the question is, how many of them are within the judiciary? And how is the Chief Justice addressing this concern to ensure that the judiciary remains to be what it ought to be, to ensure that judges dispense justice without fear of fame or being compromised in any way. And I think she has a long way to go. She still has a long way to go. And there's a lot to be desired. And I think I'll give her 3 out of 10. But of course, there's room for improvement. And I guess the Law Society has a duty to push the judiciary to do its part in terms of access to justice. The the justice, the legal and justice sector itself generally needs to put the judiciary to task, especially on those aspects of corruption, access to justice, missing judges from our courts. States who start at 12 and yet the court is supposed to start at 9. And those are serious concerns that actually paint the reputation of the judiciary wrongly. They are judges and magistrates. And I think this question of courts starting late is usually a big concern within the magistrate courts. You'll have a course list which is written that the court will start at 9. Then the court starts at 12. It is disrespectful to the advocates who appear before those courts, and it's shameful for those judges who subject litigants to that process. Remember, the advocates travel across the country to represent their clients. Sometimes an advocate leaves Nairobi for Kisumu for a case. Then in the morning of the hearing, they find a notice on the website saying that the judge is in the city. It is a huge indictment on the judiciary and its conduct, and I think it's important that the judiciary and the Chief Justice addresses those concerns. Yes.
So last week, the CJ submitted 2 amendments to the Parliament. What is your reaction towards those 2 amendments?
I have seen the publications on newspaper and on TV over the 2 bills that the Chief Justice submitted to Parliament. I have not had the benefit of reading them, but I can say it's progressive because essentially, whereas the judiciary enforces the law, Parliament makes law. And recommendations coming from the judiciary in terms of amendments of bills or introducing new bills and shaping the law to what it ought to be is a welcome move. And I think it's important that the judiciary also recommends, because you remember these bills once presented in Parliament, we have different stages that they go through, and I think the judiciary participates at some point in giving their views, the law society equally. We are in the justice sector, both the judiciary and the law society and all practitioners within this space. We have a duty, of course, to review those bills under the Parliament and also give contributions to ensure that we shape the law to what it ought to be and also change the law to the benefit of the public. And I think you have seen there are other issues of law, for instance, the Sexual Offences Act, which was enacted long time ago. It has, as the law develops, there are challenges that come with the same act. Remember, if a minor of 17 years is found to have committed a sexual offense against a minor of 17 years, and it's discovered, it is the boy child who will be subjected to judicial process, even though they are actually minors, both of them. So I think that is a big problem under that act, because it's quite, it actually punishes the one gender forcefully. And of course, we understand where the drafters came from. But again, progressively, you will realize that the law as it is does not, it helps one side and actually undermines another side. Remember, the right to children and all the children rights and all that. It's a huge issue within our practice system, and so punishing one who's a minor under the law to protect another minor then becomes a concern, a legal concern, as to whether are we undermined the right of another, even though there is, of course, the offense. And did this minor have the consent, the conscience, or the capacity to take the punishment, having been a minor committing an offense against another minor? So those are minor challenges that come in when the law is interpreted progressively. But again, it's a welcome call from the judiciary to input and rather make proposals to Parliament on issues of public interest in nature that can shape the the drafting of new laws that will enable the public benefit from the services of the judiciary going forward.
And so there's this amendment that she wants people, those who are offended, the offenders, wasikuwe kwa prison for more than 30 years.
Yes.
What's your take on that?
The proposal to change the law to limit limit life imprisonment. If you look at 20 years ago or 30 years ago, as the law progresses, we had the law that if you commit those capital offenses, you'll be sentenced to death. And progressively, I think Ochuka was the last person who was hanged as per the penal code to having committed a serious offense. Since then, the death penalty, even though issued, has not been taking effect. We have not hanged anyone since the Ochuka was hanged, and you can feel that there is that international change with regard to sanctity of life, and taking away of life on the basis as a punishment has been eradicated as we go forward in terms of protecting the rights to life. And I think progressively, and I do not know what informed the proposal by the judiciary to limit it to 30 years. But again, there are so many factors that I can think out from the top of my head. There is the aspect of course, limiting the numbers. We have so many numbers within our correctional facilities, prisons and all that. So there is that need of reducing those numbers. And the judiciary carries out, or rather their probations, their process of power mercy from the president to release a number of people from prisons. Of course, there are other factors. The life expectancy has equally gone down. From you realize if you're 40 years and you're sentenced to life, it's obvious that obviously you will die at some point. Yeah. And again, if you're 40 and you're sentenced to 30 years, by the time you're leaving, you'll be 70. The essence of prisons is for correctional purposes. Of course, the correctional purposes shouldn't include, as now the law is changing every time, sentencing to death and sometimes sentencing to life. I do not know what informed the 30 years, but I guess those are some of the reasons. And of course, I'll try and read the proposals, and even when the bill will be presented in Parliament for debate, then of course we'll know where the judiciary is coming from and where the Chief Justice is coming from with those proposals. But I think it's important that we address the concern that obviously the criminal laws in this country have never been changed for a long time, including the penal code. There are so many provisions, there are so many punishments and provisions under the penal code and the criminal justice system that have been declared unconstitutional. Some of them have been overtaken by events, but the act is still there. So there is need to review consistently the criminal laws within the country to ensure that they are conform. They conform with the constitution, and they conform with the international law and international treaties that we have signed as a country. Yeah.
All right. Wakili, so what is your greatest motivation in life apart from all this legal affairs?
My greatest motivation in life, I think, as a father, my greatest motivation is my children, and then secondly, my practice. I joined legal practice to fight for justice, and I think that tops my motivation as an advocate. I think and believe I'm still young, 5 years in practice, I'm still young in practice. I am learning to, of course, make my practice better from our seniors. At the same time, from the matters that we handle on behalf of our clients, I believe the practice environment for any lawyer gives us life and purpose to continue fighting for what we believe in, continue fighting for our clients, because they expect us to fight for them and for them to get justice. They come to us because they have concerns, and as advocates, we have a duty. And I think I get my motivation from the fact that we wake up every morning to come and, of course, fight for other people to meet their interests and find justice within our judicial system. Yes.
And what words would you have for the young advocates?
For the young advocates, I think it's important. Number one, we appreciate that we have the numbers within the practice environment. And we need to utilize those numbers to, of course, pursue our interests. We have welfare issues that, of course, the Law Society might or might not represent. But again, we have to unite as young lawyers to ensure that at least we push and speak with the same voice. And of course, the practice environment is expanding. It's important that we also take up that space. And there is room for everyone. There is room for growth. There is room for development, personal development. We should never feel that we are left out. And I think it's important to state that, of course, we have so many lawyers who are not in employment. But again, as a person, you need to also innovate, find ways to look for resources to sustain yourself, even as you look for opportunities. Ensure that you groom yourself to be a proper lawyer and do not undercut. Whenever you get an opportunity, hold and address yourself as an advocate of the High Court of Kenya, because it will be important in the second, third, fourth year of practice. How you position yourself will essentially help you to get to the next level in terms of employment and opportunities. So I believe that is the reason why I'm running equally for office, because we have to consolidate all the support from the young lawyers, the mid-bar and the senior bar, and ensure that the Law Society creates opportunities for its members within the capacity it has and within the spaces that it holds, so that we can actually ensure that both the young lawyers, the mid-bar and the senior lawyers are comfortable with the services that the Law Society gives them. Yes.
All right. I don't know if the team has any other questions for Kile.
Yes. Thank you for so much. Thank you. I'm really inspired by your words and what you've done. And as a young lawyer, this is my second practice. Yes. You have really talked about the law, the regulation of young lawyers. The main essence that I personally decided to venture out and do my own practice is because of the, let's say, mistreatment in courts by the senior lawyers in terms of remuneration, in terms of the work, in terms of how they build you up. So, as someone who has gone ahead, what changes do you think you can give, or guidance you can give to young advocates who are entering into this space?
Thank you for the question. I think I've written broadly on the question of people. Just start there, because I think it's from pupils that we transition to be lawyers, and I think the biggest problem starts there. If you look at the public sector, you will notice that pupils are actually incorporated in the negotiations, or rather in terms of stipend. The last time I checked, as of the time we were being admitted, they were given a stipend of 15,000. Later on, I hear it has progressed to 25,000. The biggest challenge is that even though we have been trying to push the Law Society to sit down with CLE and the Council for Legal Education and Kenya School of Law to formulate pupillage regulations, which includes stipend. As it stands, without a regulation, lawyers will actually hire and fire the way they want, because they have capacity. They are the ones who know how much they can be able to pay and all that. And of course, that is subject to abuse sometimes. I know most law firms pay a reasonable amount or proper amount for its advocates, but it's a growing concern because without proper regulation, and we're not, I think it's important the law side appreciate that it's not imposing on its members to pay a certain amount, because that's not possible. It's not possible to impose a certain amount, a figure for young lawyers. The best thing you can do is to share with your members the best practices. In the public sector, we have job maps or we have levels. As you grow, your salary changes from here and here. And I think law firms also hire based on your experience. If you have 2 years experience, then you set a salary from somewhere. If you have 4 years, 5 years, 7 years, 8 years, as you progress, then that has an effect in terms of how much you take home. So for me, I think we have to do the trials for pupillage alone. And this is not imposing, because the risk is that the Kenya School of Law releases advocates, pupils to advocates with only workbooks. You understand? I think they should go beyond that. And the Law Society, of course, it has said with time without number that it doesn't have, pupils are not its the members of the Law Society as per the Law Society Act, which is true. But there's another statute called the Council for Legal Education Act and the Kenya School of Law Act, which provide that pupils must go to law firms. If we were to interpret that law properly, then it would be important that at the stage of pupillage, the Kenya School of Law should hand over these students to the Law Society of Kenya for pupillage. Why do I say so? I say so because statute provides that you have to do pupillage before an advocate of 5 years and above. It means the Kenya School of Law is releasing its students to the Law Society, because for you to be an advocate and a pupil master, then you have to be a member of the Law Society. Once you come to the Law Society should accredit law firms, all law firms that take pupils. That way, the Law Society ascertains that pupil so-and-so is at this firm doing this and that. And that way, you are able to follow up on your students. The Kenya School of Law is able to follow up on its students. And Kenya and Law Society of Kenya is also following up where which member has which pupil. That is the aspect of coordination, because without that coordination of these entities, then pupils are left alone. And the kind of people you get admitted are they are extremely distraught. And there are people who have been subjected to mistreatment within law firms. And I'm not saying law firms mistreat pupils. I believe a majority of the pupils enjoy their pupillage period within law firms. But of course, to limit the few that are mistreated or chased away before they finish their work, it's important that actually the Law Society finds a lasting solution by adopting them, not necessarily taking over the work of Kenya School of Law, but assisting the Kenya School of Law to trace and to certify the law firms, because all you need to do is to give every law firm that applies a certificate of or rather pupillage. It's a pupillage center. So you're given a center certificate that your office is a pupillage center, and you can be able to take a capacity of 3 or 5 or 10 pupils. And then from there, then it will be easier for Kenya School of Law, based on the coordination. And I think we have CPDs and programs, and they can even find out what advocates need by asking for their views as to how they can improve the pupillage system, so that we formulate pupillage regulations that touch on stipend. It's good to start there. Then progressively, obviously, this trend can be entrenched within the practice, and so that we have a society that is mindful of its young ones. And again, that will help society limit the number of quacks or number of masqueraders, because if you are not admitted, again, you're practicing a court, you're masquerading. You've seen a student of Kenya School of Law who was caught, who had stolen an identity of another person. To limit that, then you have to know who did pupillage where, who did this. It will contribute to a bigger picture, to management of the profession at large, and ensuring that at least we we address those concerns that come from our young ones. Yeah, I think you're done.
Go second question.
Yes, going in the engaged. Yes, sir. I have two matters in the demand. Yes, but still, I find it hard to get dates. Yes, and my estimation is that the judicial officers are riding the assumption that there's nothing that can do to them. They are enjoying that liberty that I can even delay your date or you have to give me money. Yes. So what can we do to the judicial officers so that they with their work? It's important to state that the responsibility, when the law society is silent, the judiciary will do anything. Who checks them? The Judicial Service Commission constitutes majority of that. Of course, we have representatives. We have two representatives. But can they overweigh the majority of the judicial officers? It's very difficult. As to who's supposed to actually hold the judiciary responsible, especially when there's a crisis on the issue of dates, the Law Society has a duty. So that now, how many letters has the president of the Law Society written to the Chief Justice or the presiding judge of the High Court or the presiding judge of the Court of Appeal addressing this question of dates? So that now, if the Law Society has done that, then we can see the Law Society is not, the judiciary is not doing its job. So by virtue of the fact that there is no deliberate steps taken by the Law Society to ensure that these concerns of advocates are not addressed, you will always have those problems within the judiciary. We need to, as advocates equally, hold these people responsible, especially the staff within the judiciary. We do not want to interfere with the operations of the judiciary as it is, because they have their employers and they know their mandate. But as and when this arises, we need to address it as a law society. And that's why I said, going forward, it will be important that the law society, because we have resources, as a society we have resources. Why is it difficult? Why would it be difficult to have a law society appointed representative in those registries to collect data and address and share this information with the law society for purpose of sharing the same with the judiciary, that these are the concerns advocates are experiencing. A simple survey of going to those registries, finding out what is the problem, rooting out the problem as to who are the judicial staff members who actually sell the dates, so that we know who's responsible for these problems, and you can be able to address that problem from there. Of course, my other proposal would be that now that we have actually made it electronic to appear before court to file our documents, let the judicial process be automatic. If you take a date in the small claims court, you are issued a date automatically. Why is it difficult for the same to happen in the magistrate court, in the High Court, in the Court of Appeal? Those are concerns. So that now, if the small claims court, you can get a date automatically, why is it not the case in the High Court, in the magistrate courts? So that we automate the entire process from human interference. That way, we will not blame the judicial officers for receiving bribes, because again, who bribes these people? It is the same advocates who actually. So to address the concern, we can actually address, have the date fixing being automatic. Because of obviously it should be fed the dates, the judicial officers will not be available. And then it gives you hearing dates automatically based on the availability. That way, you limit that aspect of corruption within the registries. Of course, again, the judiciary needs to conduct sensitization and also find out who are these officers within their space who are actually committing those illegalities of actually pending dates to advocates, or threatening to give you a date after 7 months if you don't pay. Yeah. So those are real concerns. They need real solutions, and they need the law society to check the judiciary in all fronts. And I think the proposal of having a representative and a committee that addresses this issue, because the backbench committees are not, especially in Nairobi, they are not as useful because these problems still come up again every time. And also the branch needs to be facilitated properly. It's the one that is supposed to actually address these issues of dates and all that. Then we have to facilitate, as a society, we have to facilitate the branch with proper resources to be able to actually follow up and ensure that they address these issues with the judiciary. But the main office, the president of the Law Society and the council members have an overwhelming duty to ensure that access to justice is not hindered by the individuals or cartels in our judiciary. Yes.
Thank you very much. I only have one question.
Yes.
When you started looking at that process of legal journalism,
Yes.
we had a lot of bottlenecks. Yeah.
Yes.
We found out that legal journalism was essentially dead in this country. People in the legal space, to a large extent, relied on news from mainstream.
Yes.
There could be a legal matter and then they cross over it very quickly and you are not able to get the detail. So, as an advocate who has been around for quite some time, what insights could you offer us on how to strengthen the space of legal journalism and have more layers in this space?
I think you've raised a fundamental question. If you look at the case of Brian Manwa, if we had proper legal journalism, then we would not have the public and even the international community report that there's an advocate who was a fraudster who actually conducted 26 trials and won all of them. So that borders on misinformation. And if you look at what is being published in the Kenyan newspapers, you will ask yourself, did these people even bother to call and find out before reporting? And I think it's important that we have in the legal space proper journalism that can actually go into the root of the process. If you go to Milimani, you will find an office under the judiciary. There is an office for journalists in Milimani, where a space where they used to access courts and also follow up matters on behalf of the public as to whether they have knowledge to report the proper position of the court. That is a problem. So that now we need someone who's trained on the processes of courts to ascertain that this was a mention, this was a hearing, these were the directions of the court. And it's important that at every stage there is a proper written communication from the judiciary that this is the position of the court, to avoid a journalist interpreting what the court speaks and reporting as it comes. And of course, the Brian Mwenda case has opened up that debate as to whether it's time that we have proper legal journalism. And proper legal journalism will include someone who has that background to understand decisions that come from the courts and how the court interpreted those decisions, or rather communicate the position of the court without necessarily missing, because there are so many misses in that reporting. And if it was not for them picking up a blogger's statement that he has won 26 cases, which has become now a global conversation based on misinformation. So it's key, and I think we need to incorporate this within the law society, even the judiciary, and even within the justice sector, so that any communication that comes from these entities can quickly be ascertained. And it's important that we might not solve the problem of bloggers picking out and speaking differently, but as an entity, the legal, you have within you legal experts or lawyers who can be consulted on a subject. And I think you have a good space to come clean on those issues whenever there is misses from the general public. And of course, that way you can be able to give a true position as to what transpired in court or what transpired in a particular matter, to avoid that misinformation, which obviously has a serious effect on our practice environment. These other entities, including the media houses, they have a duty to have a legal department, which department interprets the positions of the courts on their behalf before they communicate. Because again, misinformation has its effect in law. If, for instance, you communicated the wrong position, which affects a company, or you reported wrongly as to who did what, you are susceptible to being sued for defamation and other, thoughts that will essentially affect that organization. So it's important that actually they pass any publication through a proper audit process, and even calling the judiciary to ascertain a position, because I know they have numbers within their website where you can call and ascertain certain information, including the law society too, especially on the question of Brian Mwende. It was very easy to call the law society and ascertain these facts, and all call the judiciary and ask them which are these cases that this gentleman has appeared in. So that way it will be easier for you to communicate properly.
Yes. So on the questions which are online, I think most of the questions you touched on, people asking on subsidizing on the PC which I've spoken about. Like was talking about the Brian Mwende case, I'd like to hear what you have to say about it. I think we have spoken about the 3 points which I've also spoken about. So unless Susan, you have any question, we can come to the end of the session. Right? Yeah, so thank you very much, everybody. Thank you, John. Thank you, actually, for having us. We really appreciate it.
Thank you so much, and continue the great work you're doing at the LICO, and be blessed with the sound.